This is Robert Dixon. Robert Dixon, in the fall of 1973, was the head of the Justice Department's Office of Legal Counsel, the OLC. OLC is the office inside the Justice Department that essentially advises the Attorney General on the legality of complex legal matters. The OLC drafts legal opinions, they research the constitutionality of certain issues that arise, they give the Attorney General official OLC guidance on legal stuff. And in the fall of 1973, when Robert Dixon was the head of the OLC, there was one specific important matter that dropped on his desk like a load of bricks. And it had to do with Spiro T. Agnew, who was then the Vice President of the United States, and also a crook. A team of young federal prosecutors in Baltimore had discovered earlier that year, in the spring of 1973, that Vice President Agnew had been conducting a bribery and extortion scheme for the better part of a decade, demanding cash kickbacks in exchange for government contracts that he controlled. Agnew started running this criminal enterprise when he was the top elected official in Baltimore County, Maryland. He continued it when he became governor of Maryland. And in 1973, right after Agnew had just been reelected to his second term as vice president, these federal prosecutors had discovered that he was running that same criminal scheme from inside the White House as vice president. He was literally taking envelopes of cash bribes inside his vice presidential office. And because of what those prosecutors had turned up, that fall of 1973, Attorney General Elliot Richardson had a problem, because he knew what Spiro Agnew had been up to. He knew that if Richard Nixon were to go down in Watergate, an active criminal was next in line to replace him. But it was not entirely clear to the Attorney General if the Justice Department, could actually bring charges against the Vice President. It wasn't clear if it was legal to indict a sitting Vice President of the United States. Spiro Agnew's defense lawyers, in fact, were loudly proclaiming that you could not. They were saying to anybody who would listen that Agnew was immune from prosecution simply because he was vice president. And that's where Robert Dixon came in, because that fall, as head of the OLC, it was Dixon's job to figure out what exactly the Justice Department's policy on this, what the Justice Department's position on this question should be. Can you indict a sitting vice president? I mean, this wasn't a theoretical concern at the time. There was a 40-count felony indictment against the vice president simmering on the proverbial stove in a U.S. attorney's office in Maryland, ready to be served up at any time. Was he, in fact, immune from such federal charges? Could that indictment be filed against him? I mean, legally, they needed to know. Also, practically, with Nixon teetering because of Watergate, with the threat that the guy who would succeed Nixon was a known and active criminal who had been taking bribes inside the White House, the Attorney General, Elliot Richardson, needed to know if he could use at least the threat of being able to indict Agnew in order to force Agnew out of office, thereby protecting the presidential line of succession. Now, Robert Dixon had been a law professor before he was head of the OLC. He was a respected legal voice, especially on voting rights and election law, but now he was being asked to figure out if it was constitutional to indict a sitting vice president. And what Robert Dixon ultimately concluded back in the fall of 1973, just ahead of Agnew resigning his office, in the midst of that crisis around that criminal vice president, Dixon's answer when he was asked that question about Agnew, for decades now, it has been used to support the position that a president can't be indicted. But what Robert Dixon went through that fall in trying to formulate that opinion, it turns out to be kind of stunning. One of the people who we interviewed for Bagman was a former Justice Department official at the time named J.T. Smith. J.T. Smith had served at the CIA, he'd served at the Defense Department, and that fall of 1973, he was serving in the Justice Department. He was one of the closest advisors to the Attorney General, Elliot Richardson. He was Richardson's executive assistant. And J.T. Smith was there when Richardson asked the head of the OLC, Robert Dixon, to come up with an official Justice Department answer to this suddenly very pressing question about whether a sitting vice president could be indicted. And what J.T. Smith told us in an interview for Bagman is that Robert Dixon, that pressure-packed fall of 1973, Robert Dixon really wasn't sure what the right answer was to that question. Listen.
He was asked by the Attorney General, as one should do, to write an objective legal opinion on the amenability of the vice president to criminal process.
Right.
And his office dug through 200 years of constitutional deliberations and opinions. I think they ended up being in sort of a head-scratching place where the opinion could come out either pro or con criminal process for the vice president. And at that stage, one evening, I took a phone call from the late Robert Dixon, who said, "Do you have any idea how the Attorney General wants this to turn out?"
Do you have any idea how the AG wants this to turn out? And honestly, who could blame Robert Dixon? It's not like you can just pull out the Constitution and find an answer to this question of whether the vice president can be indicted. I mean, nobody had thoroughly grappled with this question before. What J.T. Smith says he told Robert Dixon on the phone that night is that Attorney General Elliot Richardson very much hoped that opinion would come out in favor of the position that you could indict a sitting vice president. Of course, we know that Richardson was looking for anything he could use to get Agnew out of office and out of the line of succession. Robert Dixon's opinion ultimately did conclude, as Richardson wanted, that a vice president can be indicted. But listen to what J.T. Smith says here. Listen to what else got folded into the opinion in order for Robert Dixon to get to that desired position.
He could have written it either yes or no. And he wrote it yes, but in order to get to yes, he had to draw a distinction between the vice president and the president. So the opinion came down on the side that the president's constitutional duties are so important that it is not acceptable for the president to be subject to criminal process while in office. But by distinction, the vice president, whose duties are nowhere near as important, can be subject to criminal process. And that's one of the memos now cited for the proposition. But when it was written, it was a very close question, and the professor in charge of the Office of Legal Counsel wasn't clear how to answer it, but it got answered against the imperative of dealing with the Agnew heartbeat away problem.
Got answered against the imperative dealing with the Agnew heartbeat away from the presidency problem. And that's sort of critical here, right? For then and for now. I mean, what the Dixon memo said in 1973, what that memo said was you could indict a vice president, but incidentally, you couldn't indict a president. And the way that the history of it has been remembered since then is that 1973 OLC memo was written specifically with the Richard Nixon Watergate problem in mind, and it was a definitive look at the issue of whether a president can be indicted. And even in the context of Watergate, they believed that Nixon... Really, it was about Agnew, and specifically trying to get to an outcome where the answer would be, yeah, you can bring charges against Agnew. I mean, what J.T. Smith is saying here, and again, he was there when it was written, is that in the course of expressing the view that a vice president can be indicted, which was the imperative of the moment, Robert Dixon opined on the president's amenability to indictment, but that wasn't the intent of the memo in the first place. It just asserted that about the president in order to make the relevant case about the vice president, which is important about that history. It's also important in terms of how that memo became woven into what we currently understand as how the Justice Department works. Because to some extent, the Justice Department position right now that a president can't be indicted, it rests on the conclusions of that 1973 Office of Legal Counsel opinion by Robert Dixon. I mean, that's where it started. That's the foundation. The Justice Department did take another look at the matter in 2000 during the Clinton administration. But the roots of this position, which is a position that stands as DOJ policy today, it starts with this 1973 DOJ opinion. We've spoken to J.T. Smith some more about this in recent weeks, and what he says about the drafting of that OLC opinion in 1973, as somebody who was there, it's just striking, given the role that that memo now plays in lending de facto immunity to the president from prosecution. Again, remember, he told us, quote, When prepared, its purpose was to allow indictment and removal of Agnew and not to serve as the last word on indictability of a president. He also says that OLC opinion, before concluding that a sitting president can't be indicted, it reviews some important historical material that actually could support an opposite conclusion. And when you read that 1973 opinion in full, what J.T. Smith is saying there is true. I mean, in terms of the historical record, Dixon's OLC opinion states right there in black and white that, quote, there is no express provision in the Constitution which confers such immunity upon the president. And that's noteworthy because the Constitution does expressly provide some limited forms of immunity from prosecution for other officials, including members of Congress. But there's nothing in the Constitution providing immunity from prosecution to the president. Dixon also notes in the opinion that when you go through the various writings of the founders and the Constitutional Convention debates, quote, there are strong statements by others to the point that the convention did not wish to confer such privileges, meaning immunity, on the president. Later on, he says, quote, the historical evidence on the precise point is not conclusive. And yet, he ultimately puts in at the end that even though you can't really make heads or tails of what the framers of the Constitution intended, quote, during the past century, the duties of the presidency have become so onerous that a president may not be able fully to discharge the powers and duties of his office if he had to defend a criminal prosecution. So this is where it all comes from. This was the original document. The full reasoning from the OLC in this opinion about indicting the president is that there's nothing in the Constitution about it. We don't know what the framers intended about it at all. But the job of being president has become so hard now that it would be really hard for a president to get his work done if he was prosecuted. I mean, that's the thickness of it that's laid out in this 1973 OLC memo. And again, the issue was revisited in the year 2000, but this is in part the foundation for the view today, which we've all basically come to accept, that a sitting president is immune from indictment. Except maybe we haven't all come to accept it. I mean, looking back at the thinness of these foundations and the contemporaneous commentary of people who were there and saw how that stuff was written, it's interesting to see now that common wisdom being challenged. I mean, one of the things that has been fascinating to watch just over the last few weeks and months is high-ranking Democrats in Congress quietly but steadily starting to call the question on whether internal Justice Department policy, which is in part based on that 1973 memo, whether Justice Department policy really does definitively preclude an indictment against a sitting president. Democrats expressing doubt about that now include the chairman of the House Judiciary Committee, Jerry Nadler, and the chairman of the House Oversight Committee, Elijah Cummings, and the chairman of the Intelligence Committee, Adam Schiff. It also includes the Speaker of the House.
Do you believe the special counsel should honor and observe the Department of Justice guidance that states a sitting president cannot be indicted?
I do not think that that is conclusive. No, I do not. I think that is an open discussion in terms of the law.
It's an open discussion in terms of the law. Democrats have been telegraphing for a few months now that they believe a sitting president can be indicted by the Justice Department, despite whatever you might have heard about what current internal Justice Department policy is on this matter. Earlier this week, there was a report at Politico.com that, quote, legal circles are buzzing over whether SDNY might buck Justice Department guidance and seek to indict a sitting president. In other words, they're talking about the prospect that federal prosecutors in the Southern District of New York specifically, they might not necessarily feel beholden to that Justice Department policy about a president being off limits from indictment. And now we have someone who was there when the roots of that Justice Department policy was first crafted, saying in pretty blunt terms that the opinion formed back then was never meant to serve as the last word on the indictability of a president. And just to put a fine point on it, J.T. Smith told us, quote, it would be timely and appropriate for the Justice Department and Robert Mueller to reconsider the shaky policy regarding indictability of a sitting president first formulated 45 years ago in this OLC opinion in 1973. J.T. Smith told us, quote, the durability of this opinion is curious. We all believe that the president can't be indicted because that's Justice Department policy that says you can't. That Justice Department policy, according to people there at the outset of what made that policy, say that the durability of that idea is curious. And this is shaky policy. It is shaky policy that ought to be reconsidered by the Justice Department, according to someone who was there at the creation. That's the policy that is supposedly preventing any potential indictment against a president, even today. So what do we do with that now, especially right now, given what's going on with this president? We've got just the person you would want to ask about it next.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.